Good morning, everyone. We're just going to start here in just a second. We're just going to give a minute or two to allow everybody to log in. Okay. Well, good morning. Thank you guys for joining. Welcome to today's webinar, 5 IP Protections for AI Contracts, sponsored by Scott and Scott LLP, an intellectual property and technology law firm located in Southlake, Texas, recognized by Finance Monthly magazine as the best technology law firm in the USA. Your presenter today is Rob Scott, managing partner. He has developed a practice area helping clients to realize the opportunity of AI while mitigating risk. Today's presentation will be recorded, and you will receive a link in the next few days to access it. Please enter any questions in the question box, and if time allows, Rob would answer those questions at the end of the presentation. For those of you wishing for Illinois, California, or Texas CLE credit, Diana Peterson will follow up with you after the webinar is completed. For those for CLE credit, there is a handout in the control panel on the right side of the screen in the handout section for you to download. You will also receive a short survey requesting feedback on today's webinar and any ideas for future topics. We'd appreciate hearing from you. And now I'll turn it over to Rob Scott for the presentation.
Thank you, Marcus. Good morning, good afternoon. Thank you for joining. I appreciate the opportunity to present this topic to you. I have been spending quite a bit of time in my practice focusing on artificial intelligence and its impact on our clients specifically and on the law in general. I've been writing numerous articles about AI, both from a standpoint of intellectual property as well as transactional topics, including risk balancing and liability-related issues, as well as covering what I consider to be explosion of regulation related to artificial intelligence. And the reason I'm spending so much time and attention in this area is I, like many others in the industry, think that AI is on the verge of becoming a very significant part of the way IT is consumed in the world. And industry analyst Gartner, for example, reports that a number of enterprises planning to implement AI grew by 270% over the last few years. That same analyst is predicting that 21% of their customers that were surveyed in 2018 indicated that they would deploy AI-based solutions in the next 12 months in 2018, and that number jumped to 23%. And in 2018, 4% of the companies that they surveyed were in production, and just 1 year later, 14% were in production. So what we're seeing is significant interest in AI, and many businesses, enterprises already utilizing AI in various ways to automate functions, analyze data, improve decision making, reduce labor, and in many other ways. Harvard Business Review had a feature article on artificial intelligence. It's on the cover of one of their recent editions, and that publication predicts that AI will add $13 trillion to the global economy from 2019 to 2029. So over the next 10 years or so, Harvard Business Review is predicting very significant increases in uh, GDP growth related to AI. So one of the things I've been wrestling with is, what does this mean for lawyers? What does this mean for the law? And as lawyers, what do we need to be doing to make sure that our clients that are interested in taking the advantage realizing the advantages of artificial intelligence are also being properly advised with regard to the risks? And even in the engagements that I've been working on, it has become very apparent to me that the risks are numerous and potentially unforeseen, and that those risks are not to be trifled with. And as lawyers, we have to be very, very careful as we advise clients on the adoption of AI. And even lawyers like me who have spent their career in technology have to appreciate the fact that artificial intelligence is creating some new challenges that didn't exist in technology law prior to the use of artificial intelligence. And some of those challenges relate to the treatment and protection of confidential information, how to define, what is confidential information. In some ways, as lawyers, we have come to believe that, boilerplate language on confidential information is just sort of standard language that's, not necessarily something that we need to pay close attention to or negotiate heavily. But when it comes to AI, actually the definition of confidential information can be one of the most critical provisions in the contract. And the reason for that is AI is based on, in many ways, data, and that data is very important, and how that data is used, managed, and shared can be critical to preserving your client's competitive advantage, and defining those trade secrets and defining what is the confidential information and how it can be used and shared is a critical piece of AI contracting. In addition, there are important issues related to copyright law, and I put copyright copyleft because the issues related to software comprising the AI solution can be both proprietary, which is the copyright piece, and then those of you who are familiar with open source and the concept of copyleft, this is an issue that arises both with respect to open source models and proprietary models. And in the context of AI, you have frequently a number of applications or solutions, and some of which may be proprietary, others of which may be open source. And it's completely necessary to understand all of the copyright implications of the solution, as well as making sure that any open source technology is dealt with appropriately from the perspective of contracting, licensing, and also compliance with the open source rules that may be applicable to the particular applications that are in question. The other piece is regulatory compliance. As I said, there's been, quite interest among regulators in the context of AI, and overall, we've seen, in the last 10 years, a significant explosion around regulations of IT in general, and specifically around privacy and security regulations. And these regulations are starting to directly address AI. And for example, GDPR has a section that Article 22 that says you can't use artificial intelligence to use profiling. It's against the law under GDPR. We have new laws in California, CCPA. We have New York Shield coming online this month. We've had a number of regulations adopted in California regarding fake pornography and campaign ads. We've had legislation in Illinois regarding the use of AI in the context of evaluating video submissions for job applications, and I suspect that this is just the very beginning, tip of the iceberg when it comes to regulatory issues that will intersect with AI. And therefore, anytime you're dealing with an artificial intelligence project, advising a client with respect to AI, whether that client is offering a solution or consuming a solution in terms of procuring it and looking to adopt it in the business, the regulatory compliance implications of that are very significant. Data sharing and use rights, very important to understand. If you're dealing with vendors, if you're putting your data in a system, it's extremely important to understand how that data will be used, shared, what exactly it will be used to do. And in many instances, the data, when it comes to AI, the data is the secret sauce. You know, we used to think in terms of software that the code was the secret sauce. But when it comes to AI, it's the data that's the secret sauce, and you want to make sure that you're not contributing your data that will be to the benefit of the vendor that you may be working with, and to the benefit of perhaps your direct competitors, unknowingly. And a lot of the agreements that we see that are provided by vendors do not do an adequate job of limiting and defining the circumstances under which a client's data can be used or shared, and that's a critically important piece. And all of these represent some unique challenges to the lawyers. The other thing that is really challenging for lawyers in the context of AI is there's a whole new set of terminology that exists in AI that is different than what we've seen in other technologies. And without a thorough understanding of that terminology, it's impossible to really advise clients on intellectual property issues related to IP. And so one of the first things that I began doing is I put on my intellectual property lawyer hat, and I started thinking about, you know, what is the IP that's relevant to a transaction? How do we define it? And how do we deal with it from the perspective of advising clients or as part of a negotiated commercial discussion regarding a procurement deal? And it became a much deeper exercise than I anticipated. And the balance of this presentation will be to share with you what I've learned in that process. So the first AI artifact that constitutes IP is input data. And input data is a very specific thing, and it really is the type of thing that customers will be putting into a solution. And we have a number of examples here, but it can come from a variety of sources. It could be entered manually. It can be uploaded from documents, databases. It could be consuming, feeds of data. It can come from a existing IT system. It can come from a Internet of Things sensor or other internal or external source. Input data can be synthetic or generated through simulations. It's really anything that the customer would input, load, provide into an AI system. And it's very important that all of this data, this input data, be defined very broadly, because, as I said early on, the data when it comes to AI is the secret sauce, and input data is the critical IP artifact that the customer needs to be protected with. It's the type of thing that, if you're not careful, can lead to very big problems for a client. And examples could be texts of resumes, photos of faces, revenue reported to the SEC, could be medical images, it could be any number of records related to clients, could be related to transactions, it could be any types of things, it could be applications for insurance, it could be applications for underwriting of credit, really anything that is uploaded into a system by a client could meet the definition of input data. And the ownership of input data is almost always needs to be allocated to the customer, unless that data was obtained from a third party or from a public source. Now, it could be the case that a customer is using an AI solution to analyze data that's not proprietary to the customer. It comes from a third party or a public source, and that input data, therefore, would not, just by virtue of the fact that the customer is loading it into an AI system, doesn't change the ownership rights from that third party or public domain to the customer. But it's critically important that everything that is owned by the customer that's loaded into the system, or in many instances derived from the system, should be allocated in terms of ownership to the customer. And, my approach is, if I'm representing a customer, I'm going to be looking at expansive definitions of customer data, expansive definitions of input data, and very broad trade secret provisions related to protection of all input data by the client. And as a related topic, this is the subset of data that will typically be the subject of a data sharing and a use rights agreement. And from the customer's perspective, that data sharing and use rights needs to be very narrowly tailored to protect the client's trade secrets. It's a little advertisement for Apple for you guys. So that's input data. This is the very important. It relates to the definition of confidential information. It could relate to the definition of customer data in an agreement. It's critically important to define it carefully and to make sure that the data sharing rights associated with it have been narrowly tailored. So the next sort of big category of IP artifacts related to AI is output data. This is the data that's generated by a model that includes predictions, segmentation, actions. It could be the generation of an image, a video, a voice, a text, a report, a recommendation, a probabilistic, calculation. This is sort of what comes out of the other side of the model. You input your data into the model. What comes out of the model is output data. Examples would include a text of a magazine article, generated images. We talked earlier about deep fakes. These deep fakes are the subject matter of the laws in Assembly Bill 602 and Assembly Bill 730 in California. Came into effect in January of 2020. That makes it illegal to use deep fakes in connection with pornography or political elections. So But these are examples of output data that come out of AI systems. Could be numerical calculations, classification, critically important, of data subjects based upon race. Could be any classification. Log files related to deployment of equipment. This could be information produced as a result of output from AI systems that relate to autonomous control. So a lot of examples here, but this is one where you're really going to have to fight to very carefully identify what the output data is, and if you're representing a client, to start from the position that it's going to be reserved to the client. And then if there are specific exceptions, which there likely would be, those exceptions need to be clearly articulated and limited in scope. But you don't want to be in a situation where your client owns the input data and the vendor or third party stakes a claim to the output data, the results of what the model kicks out. That data which is generated by the model needs to be reserved to the client unless there are very specific situations where it makes sense through negotiation that it should not be allocated from an ownership perspective to the client. And it requires us as lawyers to dig in and really understand, what is the model? What does it do? How is it used? What is the output data? What potential risk to the client exists if that output data is owned by someone else or used by someone else or shared with a competitor? And so I like to, again, start from the perspective of defining it broadly, reserving it to the client, and then negotiating the exceptions from there. But the key here on the legal response, specifically defining the output of the model. What does it do? What does it spit out, right, specifically? And then understanding and allocating that ownership and use rights to the client, or, as the case may be, a meaningful negotiation with respect to protecting the parties to the transaction. So a lot of people think about AI as being primarily a mathematical exercise. And to be candid, AI in large measure is predicated on the use of algorithms that may have existed in other contexts. They are in many ways, in the public domain, frequently developed long ago by mathematicians, in some instances even before computers existed. But these algorithms define an explicit procedure that gets implemented through a programming language and is used to indicate a procedure to generate or train a model. And it's also known as learning procedure. And there are variants of models and algorithms, and those variants include a supervised approach, which is, the system spits out an output or a result, and there's human intervention, and the humans make the decisions based on the output. Unsupervised, which is where the system makes output, and based on that output, actions are taken without the intervention of human beings. And then there's reinforcement. These are types of machine learning models. And one of the questions that I asked early on that I thought was the big differentiator between traditional software IP and AI-based systems is, who owns the learnings? If we're teaching these systems to learn, and these systems are learning on their own, then there's a category of IP here related to the learnings, which is wholly new. I mean, this is not anything that any of us have ever encountered in technology law. In traditional software, we don't have these learnings like this. There's no category of IP that doesn't exist at the time of the transaction. And that's what's so unique in this context, is that there's a whole category of intellectual property that doesn't exist at the time that you make the deal. And that, in large measure, is referred to as the learnings, that the training of the algorithm, the training use of the algorithm to train the model, is what machine learning is in large measure predicated on. And I've given you some examples of algorithms that are used in AI, and the deep neural networks are the most powerful and the least explainable. And when you start talking about training and learning, you have to ask the question of explainability, which is a critically important concept in the context of AI, and the relationship between explainability and accuracy. And so when you get down into deep neural networks, it's generally understood that you have extremely high accuracy, so the solution works great. But explainability is very challenging, and your ability to account for how the system did what it did is more limited. And so I have written articles and taken the position that explainability is required, even if it gives up accuracy, for any solution that is going to be dealing with regulated data, or from which decisions will be made in a business where those decisions put the business at a high risk of civil or regulatory liability. Because if you don't know how the system made the decision, how can you defend your company in the context of a lawsuit or a regulatory response? If this is a topic that's of any interest to you, you can go to our website. I wrote an article on this topic related to Apple's work with JP Morgan in the launch of the Apple credit card, and JP Morgan's alleged use of a black box AI solution that couldn't be explained. And there's an interesting legal analysis there. I think the title of the article is something along the lines of what happens when artificial intelligence discriminates on the basis of sex. So that's on our website at Scott & Scott LLP, along with the other recent articles that I've written in this area. In the context of the algorithm, these algorithms are generally not owned by anybody. Frequently, as I said, they're based on mathematical principles that may have existed long before computers were even invented. But in some instances, a vendor, a client, or even a third party may have developed an algorithm. I think a famous example that you might appreciate would be the algorithm used by Facebook to match or people. That would be a proprietary algorithm. But a client may have developed one. A vendor may have one and have predicated a solution based on it. And there could be a third party that is coming to the table with an algorithm that they own. So it's very important in this context to understand if there are open source licensing rules applicable to the algorithm, which there frequently are, and to also carefully consider indemnity provisions related to third-party claims, because the algorithm and the training and the decision making and the learning are areas where there's potential for significant legal action, both in terms of civil liability as well as regulatory exposure. And it's very important to be very careful with respect to understanding exactly what algorithms are being used, who owns them, how the business is going to train the model, what level of supervision, if any, is going to be associated with it, and importantly, understanding what level of explainability will exist from a business perspective with respect to the solution. The model. I think a lot of people would say that the model is a very important part of the AI solution. And in some ways, fairly difficult to understand at first, the relationship of the model to the other artifacts. But the model is the representation of any function logic. It's typically relating to input data in one or multiple steps to an output. Outputs are typically predictions, classifications, prescribed actions. Examples of models include knowledge, graphs, decision trees, neural networks, deep learning networks, and many more. The model is the representation of the function and the logic. It's examples are be like, will a patient develop diabetes? How much inventory should we buy in the next month? What clients should we target with our new product? Models are being used to take decisions, to analyze healthcare issues, to decide what stocks to buy or sell. The model is what leverages the AI to answer very specific business or policy or other important questions that we're trying to get answered. Think about if you had a solution where you can ask it things like, will a patient get diabetes? How likely is this particular patient, based on everything we know about it, to get diabetes? Think about a model that allows you to determine, using real-time predictive analytics, when to buy things, how much, when to roll a truck to load an ice bin. These are all things that can have a huge impact in business, in healthcare, and public policy. This is one of the central value propositions of artificial intelligence. And the model is one that is maybe the most difficult to allocate the ownership of, because there can be so many varieties and so many approaches, such that the model can be owned by the client, a third party, an open source project, can be owned by a number of parties. For example, in healthcare, there's a lot of sharing of models, where a model can be shared by a number of healthcare organizations, where they have restrictions on sharing data, but they all want to leverage the power of the AI. So they're working around HIPAA regulations to not share healthcare information, but instead they share the model. They own a shared model and are using the learnings, transferred learning method to where multiple parties can get the benefit of cumulative and shared learning without sharing data in a way that would be, for example, prohibited under HIPAA or other regulations. So understanding the model and carefully defining the model requires a technical discussion. It requires probably quite a bit of negotiation. And this is something that you really need to define in your agreement. This is the model. This is what it does. This is who owns this part of it. This is who owns that part of it. This is who can use it and under what circumstances. These are the restrictions, etc. And again, this is brand new. I mean, these are not concepts that we've had to negotiate and understand in the context of software, for example, and cloud-based solutions or on-premises deployments. These types of discussions are new to AI and important for lawyers in this area to be mindful of. So a lot of the money that's being made in AI today, and a lot of the value that's being derived from AI today is being derived from AI platforms. Can be defined as a software environment to develop, test, and deploy and manage AI solutions, including the gathering of training and validation data and the training of model using algorithms. AI platforms are generally owned by the vendor. And when you look at the examples, you'll see exactly why. Because the big AI platforms are owned by the major publishers. They include Microsoft's Cognitive Services, IBM Watson, who is probably one of the key players in this area, the Amazon SageMaker, the Google Team Learning. These are AI platforms typically based on APIs where customers are able to connect to certain cognitive or AI-based services and leverage those services in a collaborative way where through the use of APIs, they're able to load data into these platforms, have the data they load into these platforms analyzed and operated on, and return the output data back through the API to the customer solution. Most of the transactions that you will get involved with as lawyers will relate, at least initially, to dealing with AI platforms. And this will arise, for example, if you've got a customer that's doing an enterprise agreement with Microsoft, and your customer may be using cognitive services with Microsoft. When you go to do an EA renewal with Microsoft, you now have an AI issue. Similarly with IBM and Amazon, if you're representing clients in transactions with IBM and Amazon and Google, there now going forward will be an AI component to those discussions, negotiations, and contracts in many instances. And each of these vendors has taken a different approach to the way they view the IP issues related to these solutions, and it's very important for lawyers to understand, what these vendors are saying and how to negotiate for the interest of protecting your clients. For example, all of these vendors will tell your, clients in the sales process, the data belongs to the client. Which now that you've seen, this presentation, you're going to want to say, what data belongs to the client? Do you mean input data? Do you mean output data? What data exactly does the client own? And what data do you claim the right to use, and how are you suggesting that you'll be able to use it? So these, in many instances, there has been a concern that the clients of these platforms have been donating their data to these platforms without carefully negotiating the confidentiality and use of the data from a trade secret perspective. And the work that I've been doing in this context has been really focusing on the definitions of customer data and making sure that that customer data definition expands on what we would have normally viewed as customer data in, say, the cloud or in an on-prem solution, and now to being more expansive to include these AI-specific concepts like input data and output data. So what are the legal implications beyond the IP, beyond this new terminology that we've introduced today, and why is this an area that's so important for lawyers to understand and to protect clients in? I think there's going to be a huge explosion of not only regulatory issues, but legal issues from a number of different areas. But think about liability issues, negligence in designing or implementing an algorithm or a model. You know, let's take the Apple card example, the hypothetical. Let's assume that Apple went to J.P. Morgan, and J.P. Morgan, in fact, was designed a model that discriminated against women in the context of issuing credit. That would be illegal under New York law. That would be illegal under the law of many jurisdictions. And the question would arise if that were the facts, and I'm not suggesting those are the facts. In fact, I think the facts are to the contrary of that. But this is the hypothetical that I'm positing. Who would be responsible for the legal cost, liability, regulatory, or civil litigation that resulted from that? That would be probably first and foremost a creature of contract, risk balancing provisions in the contract, limitations of liability, indemnity provisions in the contract. So this idea of legal risk and liability for claim scenarios that we have not yet seen, but that we can anticipate, and I can anticipate that there will be many. Bias in output. You use an AI solution, let's say for underwriting credit applications for mortgages, and that system is blind to race. It doesn't even know the race of the applicant, but it learns based on other factors that could be proxies for race or that would be closely correlated to race. For example, zip code, it could be an analysis of a name. And so what about an AI solution that's unaware of race, but that uses a number of other factors that constitute a proxy for race? And then when we look at the actual results and recommendations, there is a disparate impact on a particular racial minority. And there's a litigation or an investigation. The facts will say you discriminated against this race. This race was 90% more likely than others to be declined for a mortgage application. You've got a disparate impact on this particular race. How do you then go and prove that race was not a basis for the decision. If you can't explain the way the model works, if you can't explain how the decisions were taken, I think you're going to be in a very serious problem. And that's why I say bias and output and explainability are related concepts when it comes to the legal implications. Other legal implications: the data, the output, the who owns it, and under what circumstances can courts require companies to disclose the data. There are interesting cases in San Francisco about Uber and whether or not Uber was required to disclose its output data regarding traffic patterns at the San Francisco airports. And I suspect that battles over disclosure of data that companies will consider as trade secret and proprietary to them become the subject matter of disclosures in court. It's come the subject matter of significant court battles because, as I said, in my opinion, what's unique about AI is that the data is the secret sauce, not the code. Lastly, who is liable when something goes wrong? The classic example that the AI ethics people look at is you've got an autonomous car. It's driving down the road in San Francisco. It's running alongside the trolley. It recognizes that the trolley car is about to fall over on the car, and it has to make a calculation. Do I stay put, let the trolley car crush the car, in which case 2 people will die? Or do I make a hard left into the intersection where there are women and children pedestrians in the crosswalk and run those people over to save the people in the car? These are the types of ethical issues that confront AI and autonomy and that will mold the future of how we deal with the legal implications of this technology as we move forward. For example, will we use a strict liability standard related to AI? Will it be that if something goes wrong, that it's assumed that strict liability attaches? Will we look at it like a product's liability issue, or will we use a negligence standard, or will there be some other standard? What is the implication for the car insurance business as relates to adoption of autonomous control? So there's a number of legal implications, many of which we have some glimpses into, others of which we don't. But for the purposes of this presentation, the role for lawyers, I think, is fairly straightforward. If you're representing clients in artificial intelligence transactions, there's a whole new set of terminology. There's a whole new set of definitions. There's a new way to think about intellectual property. And all of this is critically important to advising clients who are considering or adopting artificial intelligence solutions within the enterprise. So just going to take a minute here to review any questions that anyone has, and want to let you guys know that if you have any questions related to this presentation, we're more than happy to field them. And if you don't get your question answered in the context of this discussion, you can feel free to email me. My contact information is here on the page. In addition, you'll see our website, Scott & Scott LLP. We have quite a bit of information and articles related to the topics that were presented here. As well, you will be provided with a video recording of this presentation, along with a evaluation form and request for your feedback, both on this presentation and recommendations for other presentations in the future. And with that, I'd like to thank you for joining us today, and we look forward to seeing you again on one of our future webinars, or discussing a particular matter with you if the need arises. Thank you very much.